In a previous lecture, we discussed the metaphysical question whether an unjust law really counts as a law. Philosophers have different views about that. But there's also a more practical question that we can ask without necessarily answering the metaphysical question. The practical question is what public officials ought to do when a law they're expected to apply requires a result that they believe to be unjust or otherwise morally bad. The most obvious cases that pose this sort of dilemma are those in which the judge disapproves of the law itself. Let's consider a hypothetical case based on actual litigation. The petitioner is an elderly woman who has a prescription from her doctor to use marijuana for medical purposes. She grows the plant for personal use in her home in California. She is charged with a crime under the Federal Controlled Substances Act. Her case comes before a federal district judge. Because California has legalized medical marijuana, her attorney moves for dismissal of the indictment, claiming that Congress has no authority to preempt California's law. However, the U.S. Supreme Court has upheld the application of the Act to marijuana possession in California in a very similar case. Informed lawyers are confident that the judge will deny the motion and proceed to trial. The law on this issue is settled. The judge knows about the Supreme Court decision. He knows that as a trial judge he's expected to follow it. However, he firmly believes that medical marijuana should be legalized. Therefore, he does something surprising. He ignores the law and dismisses the indictment. What should we say about this judge? One thing is clear. His decision constitutes what lawyers call legal error. It could be reversed on appeal. Many would also insist that the judge was wrong to make that decision. His conduct seems unprofessional at the least, and perhaps incompetent. But did he act immorally or unethically? Is his decision one that he should not have made, all things considered? If his action is morally wrong, how wrong is it? Worse than shoplifting a magazine? Not as bad as pressuring an employee for sexual favors? Should we publicly denounce the judge for his decision? Should he regret it? If he were your son, would you be disappointed in him? These are normative questions, not descriptive or empirical ones. They're questions about role morality, the moral rights and duties associated with a particular social role. Someone who believes that the federal ban on marijuana, medical or otherwise, serves important social purposes, might readily accuse the judge of unethical behavior. His decision could weaken the deterrent effect of the Controlled Substances Act and increase marijuana usage. Someone who thinks the state should ban marijuana might conclude that the judge acted unethically, regardless of whether his decision was legally correct. Of course, many people think the Controlled Substances Act should be revised, as California's laws have been, to legalize medical uses of marijuana. Many proponents of legalization would be tempted to praise judges who refuse to enforce the act. Some proponents would yield to the temptation. Others would resist it. If a legalization proponent accepts a strong principle of judicial fidelity to law, then even he would agree, perhaps reluctantly, that the judge was wrong to dismiss the charges against the petitioner. In the legal systems of the English-speaking world, fidelity entails that inferior courts must follow superior court rulings on matters of law. It also entails many other basic norms of adjudication. Trial judges must take all admissible evidence into account. Judges must apply recognized sources of law, such as constitutions, legislation, and common law rules. Courts should pay some deference to their own precedents, and so forth. The conviction that judges are bound by the law is very common among lawyers, judges, legal scholars, and members of the general public. One of the most severe accusations you can make against a public official is that he's not upheld the law in his official capacity. Nevertheless, judges sometimes depart from the law, disregarding either admissible evidence presented or controlling sources of law, such as statutes, constitutions, and precedent. When a decision is reversed on appeal, for example, either the lower court or the reversing court has made some kind of legal mistake. Judges reach legally incorrect results for various reasons. Some reasons, such as negligence and incompetence, are not especially interesting. More interesting are cases in which judges willfully disregard the law, although they rarely admit it. Corrupt judges seek to profit financially from their decisions, to reward friends or family members, or to settle personal scores. Acting for these reasons violates codes of judicial conduct. It's also morally wrong and blameworthy. Judges are ethically and legally bound to decline bribes. They're bound, ethically at least, to recuse themselves from cases presenting conflicts of interest. This lecture addresses a different category of cases, those in which judges disapprove of the legally required result as a matter of morality or public policy. They face conflicts between the law and their moral convictions. Sometimes they decide to misrepresent or disregard the law, a practice known as judicial nullification. Lawyers have different opinions regarding how much latitude judges should have to avoid morally objectionable results. We must consider cases in which the law is clear as well as those in which it's unclear. Regarding cases in which the law is clear, the most restrictive position is that judges must apply the law correctly, regardless of how unjust the legally required result may be. The least restrictive position is that judges have no moral obligation to reach legally mandated results, even when the law is clear. Regarding legally unclear cases, the most restrictive position is that judges must endeavor to apply the law correctly, even when it's not clear what the law requires. According to this position, judges must never allow extra-legal considerations to influence their decisions, even when the law is unclear. The least restrictive position always allows judges to consult extra-legal considerations when deciding unclear cases. Many writers defend unrestrictive positions with respect to unclear cases. Disregarding clear legal mandates is much more controversial, but it has advocates. The natural law tradition is often cited for the principle that unjust laws do not bind in conscience. A weaker version holds that courts are not morally obligated to enforce extremely unjust laws, those that require, for example, returning escaped slaves to their masters, stoning women for adultery, or confiscating property because of the owner's religious beliefs. Even those who reject other precepts of natural law theory might agree that judges are morally permitted to disregard such laws. In the past century, much has been written about judges who uphold the laws of extremely unjust systems. There are books about 19th century judges whose decisions facilitated slavery in the United States. Others discuss judges under South African apartheid in the 20th century. Equally relevant are discussions of judges in fascist legal systems. The post-war work of Gustav Radbruch inspired legal philosophers to think about this. Radbruch served as Minister of Justice in Germany during the Weimar Republic before the Nazi Party came to power. After World War II, Radbruch argued that a general commitment to legal positivism encouraged German officials to comply blindly with the worst of the Nazi laws. This charge was debated by H.L.A. Hart and Lon Fuller in a famous exchange published in the Harvard Law Review. Cases in which the law itself is extremely unjust are the most dramatic ones in which judges might decide to deviate from the law. More common are cases such as our hypothetical marijuana possession case, in which the degree of alleged injustice is less extreme, and reasonable people might disagree about whether it's unjust at all. Many people, regardless of their opinions on marijuana legalization, would conclude that the judge acted wrongly by dismissing the case. This conclusion could be supported with statements such as the following. The Supreme Court has already upheld the application of the Controlled Substances Act to cases like this. The justices may have been wrong to do so, but they outrank district judges. Perhaps the act should be revised, but that function belongs to Congress, not to judges. We have separation of power in the United States. Legislatures legislate, judges adjudicate. Judges are supposed to apply the law, not make it. The judge's job is to follow the law. It's what he's paid to do. The judge swore an oath to uphold the law whether he likes it or not. Everyone expects the judge to follow the law. We're all counting on it. A judge is supposed to act as a professional. The ethics of his profession, judicial ethics, require him to apply the law. If judges refuse to apply laws of which they disapprove, then we'll have anarchy. By failing to apply the law, the judge damages the rule of law, one of our basic political values. To most lawyers, these 10 observations will seem like common sense, hardly worth stating, but that doesn't entail that they hold up under philosophical scrutiny. Still more common are cases in which the law itself is not objectionable, but it requires an objectionable result. This week you were assigned to read an excerpt of an article by Anthony D'Amato that addresses this kind of case. D'Amato claims that justice is an inherent component of the law, not separate or distinct from it. Justice, he thinks, is what law is for. His main question is this: should judges decide cases according to justice and not according to the law? His controversial answer is yes. The type of case that interests D'Amato is sometimes called a gap case. This is a case in which an optimal set of legal standards dictates a result that's less than optimal. D'Amato presents an example of a hypothetical gap case. It involves a motorist named Alice who's driving down a street. The middle of the street is marked with two parallel white lines. Cars are parked along the curb, so there's no shoulder on the right. Suddenly, a child darts into the street in Alice's path. It's impossible for Alice to stop in time, so she swerves into the left lane, crossing the white lines. She avoids the child and returns to her lane. A police officer witnesses Alice crossing the parallel lines. He flags her down and gives her a ticket. He approves of her having avoided the child, but he tells her with regret that it's his job to arrest anyone who violates the law. He believes the judge will be sympathetic and let her out of paying the ticket. As it turns out, the judge is sympathetic, but he nonetheless finds Alice guilty of crossing the lines and orders her to pay a $50 fine. The applicable traffic regulation has several provisions. If a roadway is marked by a broken white line, which traverses its length, motorists may cross the broken white line if it's safe to do so, and only after first signaling their intention to do so. If a roadway is marked by a solid white line, which traverses its length, motorists may not cross the line except in an emergency, and then only if it's safe to do so. If a roadway is marked by double white parallel lines, which traverse its length, motorists may not cross the lines. The penalty for violating any provision of these regulations is a fine of $50. The problem for Alice is that the street had double white lines. She's violated Section 205C, which makes no exception for emergencies. D'Amato thinks the judge's ruling against Alice is incorrect. He expects his reader to reach the same conclusion. But here's the important part. You might assume that D'Amato would favor revising Section 205C to permit what Alice did. But he doesn't. D'Amato thinks Section 205C is just fine the way it is. Reread the excerpt if you don't understand why he thinks so. That's what makes Alice's case a gap case. The statute is good, but it dictates a bad result in Alice's case. Many legal philosophers believe that gap cases will arise in every real legal system. D'Amato argues that in gap cases it's ethically permissible for judges to decide on the basis of justice rather than positive law. This is a controversial position in the normative theory of judging. What do you think?